In the next few minutes, we're going to go over the top 5 mistakes that I see from retirees who are looking to apply for combat-related special compensation. My name is Kevin Courtney. I'm the founder of the Courtney Military Law Group and a former Marine Corps judge advocate. I help retirees apply for CRSC as well as appeal the CRSC denials. Mistake number one that we're going to talk about is assuming that the VA ruling that you have a service-connected injury is going to be enough to meet the burden that the CRSC board requires. So let's explain that. The VA essentially is asking, did you have a condition, an injury that occurred while you are on active duty? If you did, they're going to grant the VA connection, right? And all they're doing is showing that it's service connected. It occurred while you were on active duty, or you had a pre-existing condition that was aggravated. They recognize that that is an appropriate condition to compensate and to provide care for. But that analysis is a little bit too shallow for the combat-related determination. The CRSC board asks a more difficult question. What they're asking is, do you have facts or an underlying event that show this event caused your combat-related injury? If you don't have the facts or you don't have the supporting documentation, they're going to say you might have an injury, but we don't understand why it's combat related. And in order to get combat related compensation, the retiree needs to present a sufficient amount of evidence to meet their burden. There's a real case from the Court of Federal Claims from 2020 called King versus United States. There was an Air Force veteran who had served in the Vietnam era, and he applied to the VA saying that his PTSD was caused by his combat service in Vietnam. The VA looked at it and determined that it likely occurred while on active duty and therefore granted the service connection, and in terms generally qualified that it was probably because of his combat connection. When King then went to the CRSC board, he used the same evidence, and that was not enough because the CRSC board understood that King was in Vietnam, he was generally in a war zone, but under the armed conflict component of CRSC, there was not enough underlying supporting evidence to show that the PTSD was caused by a combat-related event. So that's essentially mistake number one that too many retirees make. Mistake number two is going to be focusing in on the wrong category of CRSC. If you have questions about what the different categories are, I did a video and it's linked above and you can click on that. But essentially you're looking at armed conflict, hazardous duty, conditions simulating war, or an instrumentality of war. These 4 are categories that you as a retiree have to provide supporting evidence to show that the underlying facts connect to a combat-related event that then caused the injury. The 5th category, that's pretty much automatic, is if you have a documented Purple Heart Award, that's going to be evidence that the Department of Defense, the Army, the Navy has essentially already looked at your case and determined that your injury was caused by combat. Mistake number 3 is going to be thin and uncorroborated evidence. And what do I mean by that? Essentially, it kind of goes back to number 1, which is the individual shows up with an application to the CRSC board and they've written out how they believe their injury was caused by combat-related events, and that's the only evidence that they provide. The CRSC board is going to need more than just an uncorroborated written statements by the retiree. Now, the board is looking for, again, documented medical records from the time of your service. They're looking for any kind of letters from your leadership at the time. And you might notice there's a connection or a pattern here, which is it's far more preferable that your case be documented at the time of the injury as opposed to a medical letter that's written 20 years later, looking backwards. Now, the Department of Defense Financial Management Regulation is the document that controls the CRSC board and its standards. It does say that all relevant evidence is going to be considered. It's just going to be weighed differently. What I've seen from the CRSC boards is that they're pretty much going to discount any documents that come in much, much later from a retiree, as opposed to documents that are essentially corroborating a contemporaneous event. There's a Court of Federal Claims case from 2023 called Olive versus United States. And in that particular case, Olive was an Army veteran who applied for CRSC with an uncorroborated written statements. The court came back and said, although you've told us that your traumatic brain injury was combat related, because you don't have supporting documentary evidence, you have not yet met your burden of proof. That's going to be mistake number 3, is just providing thin and uncorroborated evidence. Mistake number 4 is going to be treating the physical evaluation board results as your golden ticket. And what do I mean by that? What I mean is the physical evaluation board has a findings worksheet for you when you medically retired, and it often will say whether your injury was combat related or not. And if they've determined that your injury was combat related, too many retirees simply provide that document to the CRSC board in hopes the CRSC board is going to adopt it. Now, the frustrating part is that, at least for the Navy, there's a policy memo that says the CRSC board is bound by the PEB results. If the PEB found that the injury was combat related, if the physical evaluation board determined that the injury was not combat related, the retiree still has an opportunity to provide supporting evidence to the CRSC board to show that their injury was in fact combat related. It seems though the CRSC boards across the services today will look at the physical evaluation board results and say that's simply not enough. We need the documents that the PEB had access to in order for them to make their combat related determination. And what we're looking at today is that we need to then provide the medical documents that existed at the time to the CRSC board and let them come to the same determination that the physical evaluation board did. And you kind of need to be more strategic. You have to show the timeline of the events, right? You got to look at the combat related events, the injury that occurred, the treatment that you received after. If you just send the combat related special compensation boards 1,600 pages of medical records, you're asking them to do your homework. So instead of treating the physical evaluation board results as the kind of golden shortcut, do the homework, provide a solid CRSC packet that clearly lays out exactly what you're asking for and the supporting evidence for why you are entitled to it. Mistake number 5 is giving up after a denial. So too many retirees will submit the CRSC application, and if they get a denial, even if it's not a complete denial, but some things, they just give up. Instead, they have an opportunity to either request reconsideration to that board, and if that doesn't work, they have the chance to go and appeal their case to the Board for Correction of Military Records or the Board for Correction of Naval Records. This whole process is administrative, and they are entitled to gather their evidence and present it in a way that justifies why they believe they are entitled to combat-related special compensation. They've served, they've been in combat zones, they've been training for combat, and then they got injured. And the issue that we're seeing is too many retirees just kind of give up. If you have questions about how the CRSC boards are now supposed to apply back pay, I did a video dealing with the Supreme Court decision in Soto, and you can continue watching here because the Supreme Court did some really heavy lifting for a lot of retirees to get a lot of back pay.